Under election and I or Pam Bondi, the Department of Justice no longer represents the American people. I'm joined by former U.S. Attorney Joyce Vance to discuss the Supreme Court, the rule of law, and what we all do to fight back. Welcome back to Defending Democracy. I'm Mark Elias. Let's get started. Joyce Vance, welcome to Defending Democracy.
Thank you for having me back.
Yeah, I should say welcome back. You've been on before, and you and I have done Substacks together, and I wish we were doing more of a celebration here at the end of the Supreme Court term, but I wanted to have you on to talk about where we think things go from here now that the Supreme Court has at least taking a little bit of a break, although the shadow docket's still with us.
Yeah.
So we're going to talk about some specific cases and some specific things going on since then, but I just want to get your overall impression of where we stand, at this point.
Well, I feel like the end of the term of court could have gone a lot better. Particularly disturbing to me is the DVD case that comes off of the shadow docket, where the court decides that the Trump administration can deport people who are properly deportable, don't get me wrong, but that they can deport them to third countries without any sort of due process. And this administration chose South Sudan, a country that our own State Department says Americans must not travel to because it's so dangerous. So, we live in this moment where the Supreme Court still presumes regularity and good faith from the executive branch, and I'm not seeing a lot of that.
Yeah, so I have a couple of theories here I want to sort of put on the table to have you react to. The first is, I have noticed this over the course of the last 3 terms, that we get sort of like a flurry of like not terribleness in like late May. The beginning of June. You may remember, a case you and I both followed very closely, the Alabama redistricting case. Like that came out, like, I forget the exact date, but it came out in that time period. Then to have the final cases be really bad. And you mentioned the shadow docket case involving South Sudan. It was, just a month or
2 weeks ago. Yeah.
Yeah.
2 weeks.
Yeah. So what do you think?
I try to resist the temptation to believe that they sucker punch us with, these 9-0 decisions that show us their good faith and unanimity. I know that's one read. I think, look, the case
because there was I'm sorry, I should have finished the thought. There was a flurry of
9-0s, right? Yeah.
Right.
I think it's because those cases that are easier to decide come first. Even if they're big cases, if there's unanimity astir, then they're going to come before the end. And it's these cases with dissents and concurrences that come at the last minute. People are working on them. I'm sure that there's an effort to trade votes down to the very last minute. So I don't read anything too nefarious into it. I think it just helps us understand the process.
Okay. Can you help distill for people who are not lawyers or who are lawyers but don't practice in this area? What is the state right now of due process for people that the government wants to remove from the country? Because I felt like we had a big win. I can't remember which case it was a few months ago. Maybe?
It was the sort of the precursor to this case, right? Where the government was trying to secret people out of the country under the dead of night, and the court said, no, there's a little bit of minimal due process here.
Right. So is that still true? Or is that less true than it was?
So I think it's less true than it was. The problem is, and you know this all too well, is that when these cases come off of the shadow docket, which is normal, by the way, there's again nothing malignant at work here. This is the court's emergency docket. They use it, for instance, for death penalty cases. For other emergencies, gotta have one. But these are not cases that have been fully briefed, that have gone to oral argument, and these are not cases where we get written opinions from the court explaining its reasoning when the cases come down. So the real problem is there's an opinion, a decision made by the Supreme Court that denies these folks what I would call minimal due process before they're dumped into a third country. And we don't know why. We don't know what the reasoning is. We don't know how extensive it is. There's no guidance for the lower courts to apply. Justice Sotomayor makes that point in her dissent. And I have heard some federal judges suggesting that that's suboptimal for them. So, what boggles my mind is these folks who are like, these are criminals, these are bad people, they shouldn't have due process. Well, if they don't have due process, neither do you or I, because if tomorrow morning ICE picks me up because they don't like how I look and they decide I'm not a citizen and they boot me without due process, I've got no recourse, right? And so everyone has to have that minimal opportunity to have notice and to be heard before they're departed, to make sure that mistakes aren't made, like lumping me into the next group that goes to CCOT down in El Salvador.
Yeah. So I want to unpack a couple of these cases in a little more detail, but I want to start with the birthright citizenship case because there
I call
have
this
now
the not birthright citizenship case.
correct because there are now two parallel things happening of really big significance within this one case, right? The first is, of course, the underlying issue of whether or not the Constitution guarantees citizenship to everyone born in the United States. I think you and I agree. I know you and I agree that the answer to that is yes. That's clear on its face, though the Supreme Court did not resolve that question. And I want to put a pin in that because that gets to the second big thing that has developed, which is the Supreme Court did use one of those cases as an opportunity to address a different issue, which is when do courts get to issue injunctions more broadly than just with respect to the individual plaintiff standing in front of them, what the court calls universal injunctions, which is actually different than nationwide injunctions, though you hear some people talk about nationwide injunctions. But essentially, the court limited the power of lower courts to issue these sort of broad sweeping injunctions. So I have a bunch of questions about what this means. But the first, as a table setting exercise, there seems to be three schools of thought as to what this means. Number one, I will call the optimist case. The optimist case, and you and I know some lawyers who have voices publicly, maybe you're in this camp, say, oh, this isn't that big of a deal because there is still class action as the ability to do this. There's still APA claims the ability to do this. There's representative standing, associational standing theories. And so, yeah, this is additional hoops, but the Supreme Court didn't really change that much as the practical reality. The second school says, no, this actually was a very big deal, but it's not catastrophic because the Supreme Court itself can still be the arbiter and a functionally issued nationwide injunction. This is sort of, I think, what Justice Kavanaugh was saying in his concurrence. So yeah, it's going to create a lot of mayhem at the trial court level, unclear at the Court of Appeals level, but at the Supreme Court, you'll still be able to get these sort of nationwide results. The third school of thought, which is closer to my own, is that the conservatives didn't go through all this to just leave the class action and the rest as an easy out, that there will be a lot of cases that don't fit into those kinds of broader relief, and that it is not clear that there are 5 votes on the Supreme Court on the question of whether or not even the Supreme Court rulings are binding on a universal basis. They are precedential on a universal basis, but that's different than it being a binding, essentially, injunction. So I realize that's a lot of legal jargon for the non-lawyers out there. I'm sorry, I tried to make this clearer, but what do you think the Supreme Court did? What did it intend to do? And what is, most importantly, what's going to be the practical effect of this?
Yeah, I'm not sure I fit neatly into any of your 3 buckets. I certainly don't fit into the first bucket. On the Richter scale, California girl here, I think that this is about a 7, which is to say it's significant. I think it's a real problem. We all understand that people's views about nationwide injunctions tend to fluctuate depending on who's in the White House, right? I mean, if you're Jeff Sessions, you make that incredible comment about how can one little judge sitting on an island in the middle of the Pacific Ocean change the law, for the whole nation. And I get that, truly I do. On the other hand, there are emergency situations where nationwide injunctions are extremely important to protecting rights, because when you think about injunctions, what they do is they're not usually change vehicles. They just preserve the status quo while judges can get their arms around the state of litigation and begin to make rulings. It's nothing dramatic, right? It's press the pause button for a limited period of time. So the incredible outrage that administrations of both stripes have displayed when that pause button is pressed, I think it's a little bit theatrical. Taking this away as a tool for plaintiffs' lawyers to use, you don't need to look any further than the Trump administration trying to race the clock to get people on airplanes out of the country and giving that administration the ability to maintain with a straight face until they suddenly didn't do that anymore. That once those people were delivered to El Salvador, oopsie, right, was what Bukele said on Twitter. We don't have any more control over these people. We can't do anything. You need a legal device that stops that freezes things so that something bad that can't be undone doesn't happen. And that's my real concern about ending temporary or emergency injunctions. In this particular situation, there have been plenty of cases where the Supreme Court could have decided to take that issue up and decide it. The fact that they did it in the middle of a case where the administration was displaying bad faith, was violating lower courts' orders, I think is really despicable. And it sends a real message of disjoinder to the lower federal courts from the Supreme Court, for one thing. I think it's crazy that the Supreme Court is in essence telling the administration that it can violate lower court orders so long as the Supreme Court suddenly reverses them. That seems a little bit mixed up to me. And so I think the devil here is in the details, but we can envision any number of cases coming down the road where a preliminary injunction will be needed. As you point out, cases brought under the Administrative Procedure Act, they still qualify. Cases that can be certified as a class action, they still qualify, but I don't think I can certify a class quick enough to keep that plane from taking off.
So can you say a word about that? Because I think of all of these things, the thing that has both captured most of the public attention, some of the legal attention, but which I think I am most skeptical of is the class action, the ability to get
Me too.
the class. I'm not saying that class actions can't be brought. I think that though that there
just
are a lot
not
of ways.
Quickly, right?
Right, exactly. It's the speed, and also, this court has been hostile to class actions in the consumer space, and so like I'm not sure where that how that ultimately shakes out. And I'm just curious if you share that that intuition.
My class action expertise comes primarily from civil rights cases. I've done some commercial work too, but getting a 23B2 class certified, which is what we're talking about in these settings, it's not easy. For one thing, you've got to figure out who's in your class, right? And then you have to convince a federal judge that there are common or typical claims, that there's adequate representation. I'm leaving out the first factor, which for some reason I can't pull out of my brain, but there's one more. And usually going through that class certification process, that takes a hearing or two. It takes the judge some time to noodle the situation and think about it. That's not to say it couldn't be done more quickly, but I don't think that there's any reason to believe that it will be, especially, if you're legal learned at the ACLU, scrambling to figure out how to get this bad thing to stop. You certainly can't do it in a couple of hours in the middle of the night. So yeah, I'm real skeptical of that one. Also, as you say, there's some antagonism towards that mechanism in both the lower courts and at the Supreme Court.
I'll be right back with more of my conversation with Joyce Vance in a moment. But, in 2020, I founded Democracy Docket to track the voting and election cases that are most important nationwide. And as Donald Trump and the Republicans attack free and fair elections ahead of 2026, that mission is more important than ever before. That's why the Democracy Docket team is rapidly growing now with more than 20 people. It is supporting their work that is so critical to making sure that you stay informed. And the best way to do that, by becoming a premium member now at the link above or in the description below. So you, in addition to having done a lot of civil rights work, and I want to talk to you about a couple of voting cases, including what's going on in the Supreme Court with the Louisiana case. But before we get to that, you were a federal prosecutor, you were U.S. attorney, so you have a lot of experience in that arena. And why do they feel the need to get these people out so quickly? Like, I was really struck that, on July 4th, literally on July 4th, they were saying we have a plane to take these folks to South Sudan at basically 7 p.m. East Coast time. Now, I was thinking, like, just in a political lens, because my background is in Democratic politics and representing campaigns. Like, the optics of doing this on July 4th are terrible for the administration. But it feels like, beyond that, we are constantly in this game of like cat and mouse in which Pam Bondi, the Attorney General, and Kristi Noem, the head of DHS, the agencies they run seem to be in like an urgent need, according to them, to do these deportations. Am I missing something in the process that is required that these be done on these sort of very tight, inflexible time frames, or is this just like a plane taking off?
Well, I mean, for one thing, right, these folks are afraid that if a court can sink its teeth into the case before they act, the court will stop them from doing it.
Right, but that's not a legitimate. They're not going to tell that to a judge, right? Like, what's their stated reason?
You asked for reasons, not for legitimate reasons. Look, let me tell you the sad truth. I live in Alabama, as you well know. These are not bad things that this administration is doing. This is what I've, not me personally, right? Folks who are Trump supporters in the base, in MAGA, they're excited. They are cheering them on. They want them to outsmart the courts, outsmart those damn plaintiffs' lawyers, and get these bad, evil criminals out of the United States. And so, in essence, this is feeding the political bulldog. It's not an exercise in truth and justice. It's not an exercise in the law and the facts. And I think that's what's so very troubling to me, having served at the Justice Department for 25 years. You don't do the president's bidding. You pursue your cases based on the law and the facts. And yet we've recently seen lawyers fired from the Justice Department for telling judges the truth when they are asked questions. It's clear that this is not a Justice Department that's concerned with the truth. It's not a presidency that's concerned with the truth. It's just in every way the upside down, right? Instead of doing justice, we now do bad things that make our base happy with us. And of course, the base has been kept in the dark about the impact of this. And we're starting to see that now as people say, well, I voted for Trump, but I didn't think that they were going to deport my wife, or I didn't think that they were going to deport me. I thought they were just going to take the bad people. The truth is, whoever the administration includes in that grouping, the bad people, now has no rights.
So I want to ask you about another one of these deportation or immigration cases, and that is what seems to now be turning into a Kafkaesque novel involving Gilmar Obrego Garcia. For people that don't remember, this is the Maryland man who was deported to El Salvador in violation of a administrative judge's order that said he was deportable, but he was not deportable to El Salvador. He was then sent to El Salvador. We then spent several weeks in which the administration, including a cameo by the president of El Salvador in the Oval Office, sort of yucked it up that this guy was never coming back, predicted he'd never come back. Senator Van Hollen from Maryland went down and visited with him. This eventually, I think, public sentiment, much to the surprise of conservatives and Republicans, actually turned against the president on this. This seemed, in many people's eyes, unnecessarily cruel. And then all of a sudden, he was, in fact, brought back to the United States, only for us to find out that he had been indicted in, I think, Tennessee. Where he is facing charges. There was a lot of commentary about those charges and, some deals that were made with people to testify against him. But then in the middle of this then took sort of another turn, which is that I guess the administration now wants to deport him to another country. And a judge in Maryland wound up holding a hearing to try on the motion to dismiss the indictment?
There's a motion to dismiss and a motion to amend.
Okay. So tell us what on earth is going on.
Yeah, it's crazy, right? There are two separate cases. There's the civil case in Maryland in front of Judge Policinas, filed by Abrego Garcia's wife in her name and his name. And that was the original civil case she filed, please bring me back, right? And so there's that case, and then there's the criminal case where he stands indicted essentially on charges of human smuggling in Nashville. And most of the theatrics this week happened in Maryland in the civil case because Abrego Garcia's lawyers file a motion to amend the case. He's still in custody in Nashville. He'll be there
Right.
until July 16 because although the judge ruled that it was fair game to release him, they didn't release him out of fear that the government would pick him up immediately and deport him again. So that's all ass backwards, pardon my French,
So he doesn't want to be released?
out of fear that he'll be deported. So in Maryland, the judge is also considering what relief can she offer? Can she order them to bring him back to Maryland? Can she order them not to deport him? Because, the Supreme Court's decision and her earlier decision is essentially restore him to his status quo, which was being in Maryland under ICE supervision there, not being sent off to South Sudan or someplace like that. And it's clear, by the way, that the administration is not thinking about what the law says or what the facts of the case are. They are focused only on making up to the audience of one, right? To Donald Trump, who now hates this guy and wants him deported in an irrational way that doesn't comport with our traditional sense of law and justice. But what happens in the civil case is there's a hearing, the government brings in a lawyer, she's a ringer. I think she's a 2023 law school graduate. No, I'm sorry, I think it's earlier than that. I think she's been practicing for 5 or 7 years, working for the Attorney General's office in Florida. So Pam Bondi was her boss before. Now she's her boss again. Not somebody with expertise as a federal prosecutor. She's been at DOJ for a couple of months at best. She walks into the court and maintains that the deportation of Abrego Garcia was an isolated mistake. And that contradicts what the government has been saying for these many months. No, we were entitled to deport him. No, there's no mistake here for us to fix. They've gone back and forth a little bit, but she came out with isolated incident. Judge, you don't have to worry about this happening again, so there's no need to offer any relief. This case is moot. He's been returned. All should be forgiven. And the judge, pretty much goes ballistic and says, I don't believe you. There's a suggestion in the other case that as soon as he's released, you'll deport him to a third country. What does your client intend to do? And the lawyer for the government says, oh, I don't know. We don't have to worry about that till he's back in our custody. He's in Nashville right now, not in ICE custody. So we just don't know. And so the upshot of that is that there will be a hearing on Thursday where right. Judge Zenas has asked the government to bring forward a witness who can tell her under oath what the government's plans are.
So I don't mean to be skeptical of the courts here because we need to rely on them, but I feel like we have seen this story before, like not just in the immigration context, but like judges get frustrated. The Department of Justice lawyers seem to be not telling the truth or not knowing the truth. The judges say, well, then I need an affidavit or a status report by this time, or I need a witness, or you get to depose. They're going to get to depose a witness and they have to answer questions. But then like at the end of the day, like, how does this end? Like, I mean, do you think that in the end, this ends well for Mr. Garcia, or does the government just hold so many cards here that like, the judges can only do what they can do?
I just don't see how this ends well for him because of the animosity Trump and probably Stephen Miller have towards him. Look, the reality is he is a deportable alien who is here without legal immigration status. Whether we like it or not, that's the rule. There is an order of withholding that says he cannot be returned to El Salvador, his home country, because the reason he came to this country in the first place was gang persecution. Now, why there wasn't an intervening asylum request, I don't know. That would have been his best path, but apparently that didn't happen. And so the government could, particularly under this new ruling we were just talking about in the third party case, they could absolutely deport him to a third country. And I think my fear would be, if I were his lawyer, that they would deport him to the most punitive place that they could think of for him personally, just given the way that they're conducting these cases, not in good faith. That may give certainly the district judge some latitude, right, when she enters her order. The problem is ultimately if Abrego Garcia wins in the lower courts, even if he wins in the Fourth Circuit again, this goes back to the Supreme Court.
All right. Speaking of the Supreme Court, I said I wanted to cover with you a case that is very much in your wheelhouse and in mine, which is this case out of Louisiana. And so, for people who have not been following every twist and turn in this, uh, the state of Louisiana, like the state of Alabama, drew new maps after like every state after the 2020 census. But in both of those states, they created one black opportunity district each. And in both of those instances, they were sued. In both of those instances, they lost and were told there needed to be two black opportunity districts. The Alabama case then went up to the U.S. Supreme Court. The Supreme Court affirmed the lower court decision. There are now two black opportunity districts in the state of Alabama. The Louisiana case also went to the Supreme Court, but without hearing, it essentially got summarily affirmed. But then a group of white plaintiffs challenged the Louisiana map, saying, okay, your creation of these two black opportunity districts was race conscious. We think that violates the US Constitution's prohibition against the use of race as a predominant factor in redistricting. And therefore we want this undone. The case got briefed and argued. We get to the last day of the term. We're all sitting, we're hitting refresh. And lo and behold, I remember texting with people. I'm like, oh, the Chief Justice must have this case because he is literally the only person left who could be issuing a decision. They issue decisions in reverse order of seniority, and the chief always goes last. And then lo and behold, we're told the case is being held over and going to be re-argued, rebriefed, and potentially the questions presented expanded or changed in some form or fashion. We are, as we're recording this, still waiting to hear from the Supreme Court on exactly what they have in mind. But my own view is whatever they have in mind is not good. So, what do you make of this, and what do you think they have in mind?
Well, I mean, let me ask you the question. I think you know better than I do. You know, that Alabama case is still percolating. The state legislature actually engaged in outright defiance of the Supreme Court's order when the case came back on remand, refused to do what they were told to do. Ultimately, it was done. We voted with those two black opportunity districts. Alabama elected its second black member of Congress. First time we've had two in the House. But that case is percolating again.
Yeah, that's right.
And I wonder what you think about the notion that the Supreme Court may see that coming and maybe wanting to join those two cases and decide them together. That may give them a basis for ruling more broadly, as you say, in ways that will make both of us very unhappy. But do you think that might be what's coming here?
I think it's possible. I think that they may just want to rule more broadly anyway. I mean, the last time I remember this happening, particularly last time in an election case, was Citizens United, where the case got briefed and argued on a relatively narrow question of campaign finance law, which was whether pay-per-view movies were subject to the prohibition on electioneering communications. Case got briefed and argued. The Supreme Court decided at the end of the term, nope, we wanted argued on a broader question, a question that the parties hadn't raised, which was whether the ban on corporate independent expenditures in its entirety needed to fall. And of course it did. And so my fear is that essentially they want to know, they're going to ask whether that the Voting Rights Act Section 2, which is the part we're talking about, is simply inconsistent with the 14th Amendment. And that will be the question that is required to be re-argued, regardless of whether it's just the Louisiana case or the Louisiana-Alabama case. That would be a blockbuster of a decision.
You know, I feel like Citizens United is the model. You know, in Citizens United, they were like, oh, wait, we could make this so much better for Republicans. Let's just reissue what the basis for the decision is going to be. That was just unbelievably bizarre when that whole situation shook out. This one maybe feels in some ways less dramatic, but the results will be as long-reaching, because if ultimately the court says that you can't take into account that a state acted in a deliberately racially discriminatory manner when it drew its districts, then boy, that makes your job a lot more difficult, doesn't it, Mark?
It sure does. So in the few remaining moments I have with you, I want to ask you a question that I've listened to. I read your Substack. I watch a lot of your videos that you record. And I've never heard you address this, but you addressed this with me like months and months ago in a conversation that you and I participated in that was not online. So hopefully you won't mind me now prompting you to have this conversation in public. And that is, you were a pioneer in the use of whether you call it new media, independent media, Substack, whatever it is. You were someone who very early on understood the power of being able to provide more in-depth news, opinion, analysis, in an area that you are deeply expert, and you grew an enormous following, and it continues to grow. And I am just curious, now here we are where there are lots and lots more entrants. And I think the conversation you and I had was actually, you were like, I think you were predicting this is not as easy as a lot of people think it is the conversation that you and I are having. And I'm just curious what you make of the moment that we are in terms of media coverage, legal news coverage, newsletters, whatever it is. I'm just curious what you think. Are we in the first inning, the ninth inning? Is it getting easier? Is it getting harder? Like, do you think it's getting better or worse? Like, what do you think?
So for one thing, you're giving me way too much credit for appreciating what the changes were. I mean, literally, and I think I may have told you this, I was sitting around with two of my girlfriends, Mary Trump and E. Jean Carroll. They were both writing Substacks, and they were like, you should do this too. And I'm an appellate lawyer by trade. I spent my time as a trial lawyer, and then I spent a lot of time as an appellate lawyer. I like to write. And I thought, oh, I can maybe explain some legal stuff or some things about how DOJ works, and maybe like 20 people will read this. So I didn't envision that I would end up with just like a crazy big number of people reading my Substack every night. But I still just try to do that basic thing and be an explainer. When I started, there weren't, maybe a half a dozen people who were writing in that area, and now there's just tons, and everybody is writing, and it can feel overwhelming. And the reality is, and I think that this is the point of your question, some of that writing is just extraordinary. My former DOJ colleague Jonathan Wroblewski writes a Substack on sentencing law, and if you're a criminal sentencing law geek, and I unapologetically am, then Jonathan's Substack will be your cup of tea, and you will be delighted to have it at your disposal. The real question isn't how do you find specialty information like that? The question is, how do we take in our news overall? Cable TV seems to be waning and far less trusted. Newspapers are having their own set of issues. Substack, YouTube, even people going live on Instagram, where I used to post pictures of my knitting with my other knitting friends, and now we're all doing politics on Instagram. And so the question, I think, is a question of how do we, as high information voters, as intelligent, sophisticated people, how do we protect ourselves from disinformation? How do we decide what's worthy of our time? Because there's too much. You can't follow everything. What are we supposed to do if we want to be responsible citizens? And I think that answer is going to be very individualized. But what I always say to people when they ask this question is, find somebody you trust and read them. And maybe try to read some views that are different from your own too, right? I mean, if all you do is expose yourself to your bubble, well, you're not being very thoughtful. You really want, I watch Fox News now and then. It's hard for me, but I want to make sure that I'm not being too one-sided. I want to make sure that I'm considering all viewpoints before I decide on my own. When it comes to, obviously I subscribe and read Democracy Docket because I care about voting issues. And I feel like you're the place to go to for voting news. And then there are folks that I go to for generalized news too. Our friends Jen Rubin and Norm Eisen at the Contrarian publish a lot of articles, including on culture and art. And in some ways, to me, that starts to supplement newspapers. Maybe the last thing I'll say is, I am not a fan of urging the demise of our traditional sources of news. I feel like the result in the 2020 election rested in large part on information that we got from newspapers and television and online sources. And what we should do is work to strengthen all of those sources for delivery of reliable news, not kill off any of them. But what we need to do as Americans is to become better educated, more discerning about news, and asking these sort of basic questions. There's a program in Finland where they've trained their kids to be good consumers of
Yeah.
information. Who's writing this? Why are they writing this? When did they write it? What's their background? Is somebody paying them? Does it make sense to you? And so instead of just reading headlines and going, oh my God, there are Jews with space lasers, people need to think for themselves. And that feels very basic and at the same time very important.
Well, Joyce Vance, I always read your Substack, and I recommend it to everyone. Anyone who's listening here, we will put a link, or watching here, we'll put a link to Joyce's Substack publication. It is really an essential read to understand what is happening in court, what's happening to democracy, what's happening in the legal system. And it is not just really informative. She is a delightful writer. So you're going to love reading it. If you like to read, you're going to love her Substack. So we'll link to that. And Joyce Vance, thanks for joining me.
Thanks for having me. I always appreciate spending time with you.
Thanks so much for tuning into this episode of Defending Democracy. Please make sure you're subscribed to this YouTube channel by pressing the button right in front of you. And also subscribe to Democracy Docket's newsletters to stay informed on the latest voting rights and democracy news.